Hi, this is John Hyre, and for a little while, I am answering questions for free and not behind the paywall that is my inner circle, which has a good deal more than just answering questions. And I say just answering questions because that normally would run you 1,500 an hour one-on-one. But let's get to it. So Andy sends in a question. Why not use an IRA trust instead of a checkbook LLC? Well, let's talk about what's a checkbook LLC. When an IRA owns 100% of an LLC, why would it do that? Why would it own 100% of the LLC? Usually to get around the custodian. In other words, when I have an IRA, I have to go through the custodian to do anything, to buy assets, to pay bills. A lot of people don't like that and think, I think I'm better at this. I want to do this. I want to be in charge. How can I get my hot little hands on the IRA's money and be in charge? I want to get around the custodian. I know. We will set up an LLC. It's 100% owned by the IRA, and we'll move the IRA's money into the LLC. It's in the checking account of the LLC, and now I have the ability. I don't have to say, Mother, may I? I don't have to go to a custodian. It's now like a 401k. I can directly write checks from the LLC, which is really the IRA, because all the IRA's money went in there. I can directly write checks on behalf of the LLC. I don't need the custodian. I have direct control. I've gotten around the custodian. And so the nickname for that is a checkbook LLC, because instead of the custodian paying the bills and making the investments, you do it. In other words, you have the checkbook. And so we're going to get into that in a minute. Do I like that? Let me give you a hint. No. And I'll tell you, there's a reason why. It's not, it sounds like a great idea. There are problems with it. And I would add, 401ks are different than IRAs. 401ks are not required to have a custodian to whom you go to say, Mother, may I? IRAs are required to have a custodian. In a 401k, you can be the trustee, essentially the custodian. With a 401k, especially a solo 401k, you can have checkbook control legally as part of the law without having to go through this extra step. So if you're responsible enough and organized enough to have that great power, then you should, it's an advantage of a 401k for self-directing over an IRA. Now, if you're not really good at admin and you're not organized and you're not careful about certain rules like prohibited transaction rules, this is like giving a 12-year-old pyromaniac a flamethrower, a box of matches, a lighter, sending him to the gas station, and then wondering what could possibly go wrong. So you have to be honest with yourself about who you are. Should you have checkbook control, even in a 401k where it's 100% legit, much less in an IRA where we have to use this workaround, this checkbook LLC, so that we can have the IRA's money in our hands and do what we want with it. Now, going back to the question, but I had to give you some context and define checkbook LLC. Why not use an IRA trust instead of an LLC? And there's a certain genre of people known as Millerites, named after Jack Miller, may he rest in peace, that are fanatics about trusts, and they love trusts, and trusts are better for everything except for when they're not. Sometimes they are, sometimes they're not. As always, it depends. Now, what does he like about the checkbook trust instead of the checkbook LLC? No annual fees. And I happen to know about Andy that he's in California, and he doesn't want to pay $800 per year for an LLC when he can have the trust for free. Well, for free in terms of you're not paying an annual fee, true. But with a trust, you have to know what you're doing. There's a learning curve to truly learning how to properly use a trust. And I would say there's very little good material out there that teaches normies how to use these kinds of trusts. I see people do all sorts of things they shouldn't, or cause problems with insurance or with tax return preparers. There's a price for using trusts. You have to learn how to use them properly. And I don't think there are that many very good sources that teach you that. I certainly don't teach you that. By the way, why don't I? Because trusts are creatures of state law. And unlike LLCs, LLC law tends to be very similar from state to state. Trust law varies dramatically from state to state. I don't like the liability. I don't like the liability of teaching you how to use a trust when really I'm probably teaching you how to use it well in one place and it may not apply so well in other places. And then you come back and say, well, John, it turns out what you did works great in Ohio, but not in California, and we kind of think you're liable. I don't like that liability. It's why I don't teach that sort of thing. I've seen too many people misuse and abuse trusts. Now, I've seen some very intelligent, well-educated people use them to great, proper, and positive effect. But I've seen a lot of people really mess it up. And I would say most of the people who promote trusts as magical devices do not promote them well, or promote them quite well, but don't teach them well. So yeah, no annual fees, but your time is worth something. And there's a learning curve to learning how to use these things properly. Now, this guy says he's not concerned about liability. What does that tell me? In other words, he doesn't have rental properties and he's getting an LLC for asset protection, which even in an IRA, I think is something you should do. You're going to have to structure carefully based on what I say in the next slide. But if you're getting an LLC in an IRA because you're truly worried about liability, you own low-income rentals, that's high liability stuff. You really want to think about an LLC because the IRA does not provide the kind of asset protection that you need. Then we have to talk about some trade-offs in terms of how do you run an LLC? How do you set up an LLC that's owned by an IRA? Because there are dangers and pitfalls that I'll talk about. There always are, right? He's not concerned about liability. What does that tell me? I just want to be able to write checks. I don't like the custodian. I'm an adult. I don't need to go through the custodian. I want to write the check. I want to write it today. I want to do it my way because I'm not using this for liability, which is important because the kind of trust we're talking about doesn't provide any asset protection. The kind of trust that an IRA would own 100% of and the IRA owner would do whatever they want with the trust provides zero asset protection. And so why not use the trust instead of the Checkbook LLC? Well, I'm going to get into why I don't like Checkbook LLCs, and everything I say about not liking Checkbook LLCs applies to checkbook trusts. The fact that it's a trust doesn't change the answer. If anything, probably makes it a little worse given people's proclivity for messing up trusts. LLCs are much easier to operate than trusts. So from a lawyer's standpoint, I just, in this situation, for most people, I think a trust is not a really great fit. I think the LLC is a lot simpler and easier to do. You have to trade that off against what's $800 a year worth to you if you're in California. Now, I know we're dealing with a real estate investor, so those guys would probably kill close family members for $800. I mean, granted, maybe some of the family members for free, but in general, you know what I'm saying here. So where can I get a Checkbook LLC operating agreement and similar trust agreements? I don't know. Because I don't agree with Checkbook LLCs, I think they're a danger. I don't want the liability for saying, I don't think you should do this, but here are the documents for you to run out and do this. I don't want that liability. So am I capable? Do I have a Checkbook LLC template that if you're going to do it, you probably should use mine? I do. But I'm very hesitant to give that out because no good deed goes unpunished. Thanks for the template. If anything goes wrong, I will be in touch. Ugh, no thank you. And much less a similar trust agreement, which would be, I don't even have that because the trust agreements, again, are state by state. So do I know people who do this? Yes. Could I get such trust agreements? Sure. Do I want to be associated with those agreements? Not really. Not really. I don't think this is a great idea. Let's get into why. There was a case a few years ago called the McNulty case. And this is the case that, in my mind, destroyed Checkbook LLCs. Now, it's a little more subtle here. Why don't you hear about this case? There are two reasons. Some of what was put in there was a little bit on the subtle side. And there are a lot of people who have an interest in this case being wrong or ignored. Too many people making money off of Checkbook LLCs, promoting them. They don't like what McNulty had to say. And so they try to narrow what it said, saying, well, okay, don't do what Mrs. McNulty did, but everything else is fine with Checkbook LLCs. It's all fine. Just don't do what she did. I don't think that's correct. Let's walk through it. In the McNulty case, Mrs. McNulty used IRA money to buy gold, physical gold. She put the gold in her basement. Now, she used a Checkbook LLC. How did she buy the gold? There was an IRA that put money in the Checkbook LLC. She was the manager of the Checkbook LLC. She went and bought the gold. She put the gold in the basement. And the court said, that's distributed. What? It's distributed. You're taxable. And there are penalties if you're not of age, too, by the way. So what do you mean it's distributed? This is the IRA's gold. It's not my gold. The court said, no, sorry, Mrs. McNulty, but the minute you touched it, the minute you put the gold in the basement, you took possession of the IRA's asset. You had complete control over the asset. You took physical possession. And so we're going to treat that as a distribution. And she said, no, no, no. The nice promoter on the internet said that I am the manager of an LLC and it's a separate person. And the court said, no, no, no. Single member LLCs are disregarded entities. Look it up. Single member LLCs, as far as the IRS is concerned, are disregarded entities. And the court said, therefore, what we're going to do is disregard the LLC. So when they disregard the LLC, who owned the gold really? Mrs. McNulty. The court went further. They didn't have to do this, but they actually went further and gave a warning. They said, if you don't even need to have actual possession of the gold or the asset. If you have what's called in tax law constructive possession, it's not actual possession, but it's treated as if it were actual possession, which is really bad. What happens when you have actual possession of an IRA asset? The asset's distributed. What happens when you have constructive possession of an IRA asset? The asset is distributed, which is a negative consequence. None of us want that. What is constructive possession? When you have complete unfettered control of an asset. Complete unfettered control. Note, you don't have to abuse that control. The fact that you have complete unfettered control over an IRA asset means it's distributed. You don't have to abuse it. And I think the court was setting us up, was setting the ball up right above the volleyball net for the IRS to spike it. Now, the IRS hasn't spiked it. They're not very competent, and we've seen that over the last few years. I wouldn't assume they'll stay incompetent, but they are for now. The court gave them a slam dunk spike. Oh, mixed metaphors. Bad John. No sports. Bad John. It set the ball above the net for them to easily spike. It said if you have unfettered control over any IRA asset, it is distributed. What do you have unfettered control over with a Checkbook LLC or a checkbook trust? The bank account. You can do whatever you want. You have access to the bank account. You can write checks, you can withdraw money, you can write checks to yourself, you can take money and put it in your pocket. Oh, but I would never do that. It doesn't matter. The court said it doesn't matter if you do that. It matters if you can. In fact, the court made a very, very strong statement. Look here in the quotes at the very bottom of the slide. Personal control over the IRA assets by the IRA owner is against the very nature of an IRA. Let me repeat that because this is what a checkbook control LLC is about. This is what a checkbook control trust is about. Having personal control over IRA assets. That's the reason people want them, unless they're using an LLC for asset protection. Personal control over the IRA assets by the IRA owner is against the very nature of an IRA. What stronger statement do you want? What do you think is going to happen if the IRS gets its feces together and goes after checkbook LLCs and says, you know what, we think checkbook LLCs by their nature, because they give you personal control over IRA assets, we can nail every checkbook LLC in existence. We can just go nail them. Do you think at some point the IRS might figure out? I don't know. But let me tell you what, if they do, if an IRS lawyer is smart enough to take this to court, if they have the time to take it to court, because those guys tend to be a little bit on the busy side, I think they're going to win. I think they're going to win because the court set it up. Here's the quote. There's a whole case saying, we don't like this. Now, the people who sell checkbook LLCs for a living are saying what? This only applies to gold. It just applies to gold. That's not what the court said. You can read the case for yourself. The decision itself is actually quite readable, but there are a few paragraphs like that quoted sentence I put that are very direct. You don't have to be a lawyer to understand them. So I don't like checkbook LLCs. I don't like checkbook trusts. The only case where I recommend them is if your IRA owns high liability assets, and then I would structure the LLC very carefully, which is a discussion for another day.